Millet, file an appeal without the certified copy. Order was passed on 8th of July, Millet. The appellant, Millet, is an outstation person, Millet, so he had received instructions. We have received instructions only day before yesterday to prefer an appeal, Millet. There is some urgency. We have filed it, Millet. We will be filing it, Millet, subject to your lordship granting
which
us.
group is this?
This is group 4.
But what is the date of the order?
8th of July.
No. Yes, leave granted.
Deeply obliged. Let it appear tomorrow or day after, with slightly on the.
If you number it, give the number, tomorrow it will be listed.
Deeply obliged.
Original side daily list item number 1.
Wait, please, my lord.
But I'm appealing.
I'm appearing for the appellant in the matter.
Why it's coming under
My
the
lord,
capital to be mentioned?
Justice Rai was, well, previously Justice Om Rai was to appear, my lord. Now I've been engaged in the matter, my lord. Lordship kindly fix any day, my lord.
There's a notice which has come under section 221, my lord.
Yesterday they mentioned.
Yesterday we had
Yes,
mentioned
yes,
because
yes,
of this notice which has come, my lord, on 4th of July.
My lord,
What is the notice?
There's a section 221 notice, my lord, where the demands are indicated, and there's a penalty, my lord, notice which the date was given as 24th of July, the date for hearing in the penalty proceedings. May I hand over copies, my lord, of the notice? This is why we had mentioned, my lord.
Petition is also required, my lord. We don't have. The Lordship will kindly take next week, not Tuesday, subject to.
Given by you, this notice.
Obviously, the procedure instruction they problem. I have to take. I don't know.
Have extra copies of this?
Because there was no stay in this appeal.
There was
Yes,
no
yes,
stay
yes.
in the appeal, my lord. My lord, 50 capital C is the point involved. My lord, we are contractors, so my lord, 43 CA would be applicable to us. That's our contention, my lord.
Where is the tribunal's order?
My lord, it's at page my lord, 1669. Also in the memo of appeal, my lord.
No, 69 is the form. 71.
We have a compilation which we had filed, my lord. In the compilation, this is there. Otherwise, my lord,
In this stay petition, it is not there.
no, my lord, stay petition. It's not there, my lord. In the memo of appeal, my lord, they have annexed.
Let him serve a copy, my lord. We don't know.
We have given a copy. We've not given a copy.
It's compiled.
Oh, achha.
But the order passed by the tribunal was on 4th of October 2017.
My lord.
But you filed the appeal in 2022.
It was lordship. And then there was, my lord, condonation which was, my lord, allowed by your lordship. There's an order.
Oh, the impugned order is at page 122.
The date of pronouncement is, my lord, 14th of October 2020.
Oh, there are other orders.
Yes, my lord. The order, my lord, this is
This
for
is
the
for
year
which assessment
2012-13 and 13-14, my lord.
12,
The
13.
conjoint order.
Oh, okay. And why have you enclosed the other two orders? Page 98 and
My lord, that's because, my lord, we were relying. Where's page 98? Stay petition. Kindly grant me a moment because my papers are also, my lord. Don't have the entire set.
you give an interim reply to the AO saying that your appeal has been taken up
My lord, we will.
and we will fix it on Monday,
But may it be Tuesday, my lord.
Tuesday.
Yes.
I'm very deeply obliged. My lord.
We have heard so-and-so learned advocate appearing on behalf of the appellant. Mr. Prithu Doria, learned senior standing counsel, accepts notice for the respondents and seeks time to get the relevant instructions from the department and make submissions. List the matter immediately after fresh cases on Tuesday.
Very deeply obliged, my lord.
Grateful, my lord.
Deeply obliged, my lord.
Item number 2,
May it please, your lordship. 169 days delay in preferring this.
Actually,
Won't object, only that line in my, that's it.
what is the issue 68?
This is my lord, reopening on the ground there was bogus purchase.
Additions were made for the reasons which were not recorded in the notice. And the findings of the tribunal is at page 35.
But tribunal says that addition has been made on a different reason.
It differ for different context. But my lord, if your lordship kindly see the assessment order, there are certain categorical finding made by the assessment officer. Although my lord, the tribunal had my lord gone on to hold that there was no recorded reason that has been supplied to the assessor on the score on which this reopening has been made.
Tribunal says the reasons were something else. Addition was
Yes.
made based on something.
On a different
Because the
score.
reasons was that
In this accommodation entry received,
Accommodation center.
accommodation entry of
the
38
addition
lakhs.
was
have-
made for bogus purchase.
Bogus purchase.
That is wrong.
No,
One more
accommodation
thing, my
entry.
lord, I should point out, my lord, kindly come to page 18. The CIT's order, my lord, CIT appeals order. Paragraph 3, facts of the case. In the last 4 line, my lord, it's written that the you accepted the fact that the reasons were incorrectly recorded by mistake.
How it is curable?
But my lord, why if I could my lord only ticket that because the reason was different, because the source from which my lord this investment was made was
Become wiser, sir. Can't
My lord, may I say
It would be
one thing only, my lord. I am not that these orders should sustain, but the issue whether if the reason goes whether addition can be made for other reasons or
issue
not.
a second notice. It is up to them to.
So in the same notice, my lord, one order is my lord's order, BP Poddar Foundation. My lord held that if the reasons goes, everything goes. But there's another judgment of the Guwahati High Court. They held that the addition can be made for the other reasons also.
No.
Is it?
if your reopening is on a specific issue, then it has to be confined to that issue. But if the notice contains various details, and one among them was bogus purchase, then you can probably take forward that.
My lord, just kindly have a look at the one thereafter, my lord, whatever my lord brings.
My lord, may find it at page 11,
Hmm.
wherein, my lord, subsequent to, my lord, the reopening of the assessment, my lord, the notices were served to him, indicating, my lord, this particular aspect on the basis of which reopening is, my lord, proposed to be opened. There was no reply from the assessor on that.
Paragraph 14, my lord.
If I may indicate just one thing at the outset, madam. Question any of notice. A question any of notice. Like my grounds.
No, no, we are now. See, but it says that different information is getting.
Suspicion. Suspect.
So such issue should have come to his notice during the reassessment proceedings. Now let us see whether he has recorded. That is settled legal position. He has to say, yes, I issued notice for reopening on X, Y, Z reasons. But in the course of the proceedings, based on the documents produced, this issue has come up. Then you put the assessee on notice, hear them.
My lord, that was the issue but discussed, my lord.
In the assessment order, has he extracted the reasons for reopening? Appellate authority? No.
They haven't, but if I may indicate one issue right at the outset, but in the memo of appeal and in the questions, the issue of 147 hasn't been challenged by the department. But be that as it may, the controversy in the matter is that when the reasons were issued to me, the allegation was that I have received, the assessee has received accommodation entry from a certain entity, and that entity cannot, that entity has filed the return but has shown very meager income. Now, I had responded by providing all the details, and I replied saying that it is not a case where I have received money, but it is rather a case wherein I have made purchases from that entity and have made payments of only 38 lakhs, and the remaining is showing as my sundry creditors, and it is unpaid. Your Lordship, then he issues the order where he is disposing of my objections by saying that was only typographic, that was only an error. He's curing it under 292 BB, which, my lord, in my humble submission, my lord, it is not permissible because this goes to the root of the entire proceedings altogether. Because, my lord, he cannot initiate the proceedings on the basis of a suspicion or merely on the basis of whatever report that has come to him. And he's, my lord, changing the entire dynamics altogether. Thereafter, my lord, he conducts a 131, he issues a 133.6 notice, which he issues it, my lord, admittedly, as per the dates, after he's passing the order disposing of my objections. He does not communicate these facts to me that the 133.6 has been unserved, it has returned unserved, the officer could not find. He passes the order. But I prefer an appeal. In the appeal, my lord, I make various submissions before CIT appeals, wherein I'm saying that I've provided the bills on the base from the bills for the purchases. The transactions are through banking channels. They are duly recorded in my stock register, because one of the points taken by both the assessing officer and the CIT appeals is that I have not furnished bills. I have not. It's not declared in my stock register. Then I've also made the submission, my lord, that I have also made subsequent sales. My sales have been accepted, my books have been accepted, and my transactions are at par with the gross profit ratio. So you cannot make any disallowance whatsoever. You cannot disbelieve my purchases, but at the same time assess me on my sales. On all these points, my lord, the CIT appeals is silent. He surprisingly, he moves on the basis that even on the basis of suspicion, reassessment proceedings can be conducted. And then when the matter came before the Honorable Tribunal, Your Lordship, we made various points, including the fact that the order was passed by the officer not having jurisdiction. But besides that, my lord, the primary submission was that in the case of these 148 proceedings, my reason says that I have received money from that particular
38
entity.
lakhs and odd.
And my lord, that reason has gone, because today he's saying that no, I have in fact paid money. So my lord, the decision in Jet Airways, and my lord, which has also been considered by my lords and BP Poddar, that if the reason on the basis of which the reassessment proceedings have been initiated, if they are changed, then my lord, the reassessment proceedings go. Even in the case of Excel Commodities, my lord, my lord had considered, it's a reported decision, my lords, wherein the allegation of department was that I've received accommodation entry from entity X. But when he's passing the order under 148A(d), he says, no, you've received it from Y. So, my lord, that shows that there is no investigation done. He's only acted on the basis of the report, and that too without application of mind. And my lord, another point that we've taken on merits is that today, my lord, the allegations with respect to section 69C. Now, my lord, in section 69C categorically says, if I'm unable to prove my source of the expenditure, then the addition will be made. In this case, my lord, he's not questioning my source of the expenditures at all. He's saying that your transaction with that entity is questionable because today, as on date, I cannot find that entity. But the returns have been filed by that entity. That he's not disputing the existence
And
of
the
the
sales has not been doubted.
That has not been doubted. And it is at par with the gross profit ratio. I've even submitted that. Because, my lord, even the addition cannot be made of the entire amount. It has to be restricted to the profit element. A stock register, everything has been submitted to show that it cannot be. I'm a manufacturing entity, Your Lordship.
But in this Guwahati High Court decision, what are the facts? Which paragraph? They indicate the facts.
What it is, what?
Copy.
Paragraph 3 of the decision.
But you read paragraph 6. The tribunal, while dismissing the revenues appeal, came to be dismissed by the tribunal while holding that the assessing officer could not have made addition of any other item which
Yes.
was deducted during the reassessment of the escaped income, which had not been specified in the reopening order. Now you show from the assessment order that this is the fact situation.
Yes.
See, he may say that I issued notice for such and such reason. Then he submitted all documents, etc. During the course of reassessment proceeding, this issue is cropped up.
Cropped up.
There is nothing like that. Have you got that order disposing of your objections?
No, my lord, I haven't got.
In that he has accepted that the reasons are wrong.
Because my lord, he himself in the assessment order refers to section 2. He doesn't refer to it in the assessment order, but my lord, the CIT appeals order in where my statement of facts are reproduced, the 292 BB averment is there. My lord, may kindly take at page 18, wherein my lord the facts are being mentioned by the CIT appeals, where my lord he's recording the facts. My lord, he says that the facts.
Last.
Paragraph 3, the facts of the case are that my lord. He says the facts of the case are that the assessee filed the return of income on such and such at the returned income of nil. The said return was processed under 143(1) by CPC and thereafter it was reopened under section 147(1) by DCIT Circle 3(1) Kolkata on reasons that the assessee received a sum of rupees 38,75,000 from Chakradhari Industries, which is bogus. The assessee disputed the reasoning, the reopening of the assessment having been reopened on the wrong facts and incorrect reasons recorded by the AO. It was submitted that the assessee did not receive the above sum. Instead, the assessee had actually paid rupees 38,75,000 to the party for purchase of raw materials from them. The AO accepted the fact that the reasons were incorrectly recorded by mistake and was curable under section 292B. And therefore, he proceeded to make the addition on the ground that the purchaser was bogus.
So this very inception, my lord, I have shown that to your lordship. That recording is there. So, my lord, but if your lordship kindly turn to paragraph number 3.1 and 3.2 of the assessment order. Even if, my lord, he didn't, my lord, find a place in the recorded reason.
Yes, Your Lordship, but para 3.1 he records that the assessee has received rupees 38,70,000. He says that the last 4 lines, the non-existence of the concerned party that the address given and having no creditworthiness to make the such huge transactions, funds transferred by them to entities are being treated as bogus. The assessee has received rupees 38,75,000.
So, my lord, this part of the contention of the assessee is something which is, my lord, not find place in the recorded reason. But even, my lord, this issues has cropped up, my lord, during the process of the reassessment procedure. Now, my lord, kindly turn to the next paragraph.
Please show how it has cropped up. That has to be evident. In the Guwahati judgment, that is clear. You have gone through this Guwahati High Court?
My lord, I haven't.
You go through it.
But my lord, at the outset, my lord, firstly,
Because the tribunal in that case followed Infinity Infotech Park,
Yes, Your Lordship.
and then also Ranbaxy Laboratories, and one decision of Jet Airways
My lord.
of Bombay High Court, Ranbaxy of Delhi High Court, one Gujarat High Court, and one Calcutta High Court. And you do one thing, you produce the copy of the reasons,
My lord.
the reply given, and how he disposed of.
I will. But
If he has disposed of the reasons on a different ground, will it be saved?
my lord, I have two other points, my lord. Firstly, my lord, a technical point that this issue 147 that has not been raised by the respondents, by the appellant, in either the grounds of appeal nor in the questions of law. So they've not even made that challenge before, my lords, at the very outset, madam.
Then what is the substantial question?
Section 69C. They're only limiting themselves to section 69C. Kindly take page 6, my lord.
So reopening was not an issue at all.
So they have not raised reopening as an issue at all, Your Lordship. And Your Lordship, secondly, my lord, even if the reasons, my lord, even if say a detection is made, assuming, my lord, that the detection is made subsequently, etc. But my lord, today when he's assuming the jurisdiction, he needs to have made, he cannot do it on the basis of a mere suspicion. He needs to have made some inquiry on the basis of after receiving the material. By the issuance of an incorrect reasons by the assessing officer, that itself shows that he did not conduct the preliminary inquiry and he did not draw the necessary live link or nexus, my lord, which is directed by the Honorable Supreme Court in the case of Lakmani Mewal Das. Because there needs to be definitive information. The Honorable Supreme Court has held that there needs to be definitive information.
But the 69C, how he is justified? Tribunal says that it is not the case before us, the assessee, but this is not the case before us. Assessee has duly disclosed the total purchases of the in the books of accounts and payments made to so and so. But also out of the books of accounts with explained sources. Therefore, the source was also fully explained, and even in this count, the addition cannot be sustained.
That is the my lord, finding of the tribunal, on the basis of which, my lord, the substantial question of law has been framed.
So reopening you cannot raise. That was not a question suggested.
Not even a ground has been taken out in the memo of appeal.
You come to page 26, ground 7. This is the ground regarding 69C raised before the Commission of Appeals.
My lord. The provision categorically says that my source needs to be dubious for it to be regarded as an unexplained expenditure. He's not gone into my source at all. He's not found fault with my source at all. What he has found fault is with the party with whom I've made the transaction of purchase. So on that basis, the tribunal has held.
Says that party is non-existent.
But that is because of the fact that he could not find him in 133 when he issued the notice. But my lord, he does record that the reasons record that is when the department provided him with the information, he's filed returns. The other two parties because this information covered various parties. It does not cover the party with whom I've done transactions. They haven't filed returns. My party in question has filed returns, but with meager income. And that he has thereafter given funds. But even section 69C, in my humble submission, is not applicable. The section is reproduced, Your Lordship. where in any financial year an assessee has incurred any expenditure and he offers no explanation about the source of such expenditure or part thereof, or the explanation if any offered by him is not, in the opinion of the assessing officer, satisfactory, the amount covered by such expenditure or part thereof, as the case may be deemed to be the income of the assessee for such financial year. But he doesn't go into my source. He accepts it.
But did you inform the assessee that the other party, that so and so industries, when you issued notice under 133(6), that they did not respond?
No.
They have not.
They haven't. But I've made a specific averment to that effect.
No, no. That is not there.
And it is after a long lapse of 7 years. All right.
11,
please come.
12, 19. 11, 12, 19.
This appeal filed by the revenue under section 260 capital A of the Income Tax Act 1961, within bracket the Act, directed against the order dated June 11, 2024,
19.
passed by the Income Tax Appellate Tribunal A Bench, Kolkata, within bracket tribunal, in ITA number 929/KOL/2023 for the assessment year 2012-13. The revenue has raised the following substantial questions of law for consideration. Page 6, question number 1, 2 not required, 3, 4. Five, 6 not required. We have heard so on. There is a delay of 169 days in filing the appeal. As the delay has been properly explained and not being inordinate, we are persuaded
I'll put a pattern in the mind. Well, pattern. Absolutely pattern.
Kaushla.
প্রচুর 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 নাম করেছে অনেক ম্যাটার অ্যাকচুয়ালি আমাদের ওই সিআইটিএফ এই অবজারভেশনসটা কতটা তুমি ক্লিয়ার করো দেখবে একটু ঘুরেছি
and the production of the finished goods was supported by RG. Purchases the party non-compliant and inspector said party is not fair. Admitted this fact was never successful transaction was and law arising for consideration in this appeal. Accordingly, the appeal fails as dismissed.
Board and Beverage.
For admission of tax matters, item number 3.
I beg to appear. This is a case of adjustment of bogus loss in share trading. Now, assessee before the assessing officer did not participate, did not file any document. In a search and seizure proceedings, the director of the assessee company, he made a statement that they are giving accommodation entries. Before the CIT appeals, altogether 11 opportunities given to the assessee, he could not participate and did not file any substantial document. Before the tribunal, the tribunal was of the view that only basis of the admission of the director, the addition has been made. There is no separate investigation has been made by the by the assessing officer. He only rely the documents of the investigation wing, no application of mine, and further one paragraph is given, no opportunity of the cross examination of given to the assessee. The director of the assessee submitted, he has given the accommodation entry. I do not find from where the tribunal did that, because the assessee never says he want to cross examine, because the director himself made statement.
But tribunal says that statement was retracted
The statement was retracted after 3 years.
after 3 years.
Yes, the initial statement has been made on 18/6/2013 and retraction on 22nd March 2016. That is the whole case as it appears from the assessment record. Now your lordship kindly come some portion of the assessment order. Thereafter I will place some portion of the CIT appeals. Thereafter tribunal order is very short order. Now your lordship kindly come page 10 of the assessment order. Information received from Director of Investigation, New Delhi, that a search and seizure operation was carried on the premises of KLJ Group and consequential survey has been taken place in Kolkata in the office of the Messrs. Jadodia Finance Limited. This is the assessee. The director of the company, such and such, has given a statement on oath where he admitted that the assessee company, Mrs. Such and such, is an entry operator and involved in giving bogus entry for purchase and sale of investment share application, etc. against commission and total commission on total transaction amount. Thereafter, Milord, the show cause notice has been given seeking clarification from the Milord assessee. Milord assessee, Milord, did not file any reply. Thereafter, page 11, Milord, the assessee, no reply is received from the assessee till date of the order. It can be it can be very well assumed that the assessee has nothing to offer explanation in this defense, in his defense. Thereafter, Milord, in the Milord CIT appeals order, Milord, your lordship kindly see page 17, paragraph 4.1. Altogether, Milord, 11 notice given to the Milord assessee. Sometimes Milord 2 and 3 occasion adjournment sought for. Thereafter, Milord, no participation. And Milord assessment order, Milord, confirmed by the Milord CIT appeal. Milord CIT appeal is also, Milord, in ground wise, Milord, decline the claim of the Milord assessee. Milord, altogether, Milord, what is appearing in this thing that Milord assessee did not participate and did not file any document. Thereafter, Milord, the tribunal order. Now, Milord, tribunal order, it is, Milord, page 31, para 5.1. But it says, Milord, we also find that the learned assessing officer has not conducted any inquiry investigation into the evidence filed by the assessee during the assessment proceedings. Now, Milord, here is the clear finding of the Milord assessing officer and CIT appeals. Assessee did not comply, did not file any reply. And thereafter, we note that a search and seizure operation was carried on the such and such premises, and consequential survey has been taken place in Kolkata, and such and such was summoned under section 131 of the Act, and a statement of oath wherein they admitted that the assessee company, Jajodia Finance Limited, is the entry operator involved in the given bogus entries, purchase and sale investigation. That was next page, Milord. In the present case, we observe that assessee has filed evidence before the assessing officer as called for during the course of assessment proceedings. However, the learned assessing officer had not done any inquiry, as merely harped on the statement of C. Rajesh Kumar Surana recorded on such and such by recording the finding of para 2, page 2. The assessment order, transaction of the assessing raises suspicious and therefore cannot be accepted. We note that no cross objection was even allowed to the assessee. We note that in the instant case, the statement given on oath has even been retracted on 23/3/2016. There are altogether 3 years after, Milord, the retraction has been made. And a learned tribunal, Milord, in our opinion, it is settled legal position that confession given during the survey has not evidentiary value unless corroborated evidence are there. Milord, there is a corroborated evidence from the Milord investigation wing, Milord assessing officer, Milord apply his mind. Thereafter, Milord show cause notice has been given. Milord, the assessee did not participate. Initial, Milord, burden upon the assessee, Milord, he could show that why the bogus loss, Milord, appeared. Milord, here, Milord, nothing. And Milord, only 2 lines, Milord, from Milord one order, Milord, Honorable Supreme Court. নামটা হচ্ছে ফাল্গুনা রবার প্রডিউস কোম্পানি লিমিটেড, হচ্ছে স্টেট অফ কেরালা, I197391. Milord, here, Milord, page number, second page, Milord, paragraph number 5, Milord, last 2 lines. But here the case of the tribunal is that there is no evidentiary value of the statement taken on oath, because thereafter he has retracted. Tribunal case is there is no corroborated evidence with the statement. Now here the Supreme Court says last two line, an admission is an extremely important piece of evidence, but it cannot be said that it is conclusive, but it is open to the person who made this admission to show that it is not incorrect. Here assessee given ample opportunity, he could not take that.
I think the
Yes, ma'am.
I think tribunal committed a factual mistake. I think they cut paste some other order.
My lord, may I just take your lordship to one fact, just one fact.
No,
Kindly
this is perverse, sir. Fellows don't apply their mind. He says we observe that the assessee filed evidence. And what is the effect of retraction after 2 years? Mere retraction
about
will
3
not
years.
remove the.
there are two ways of looking at it, my lord. My lord, kindly take one paragraph from the assessment order, just for once. Kindly take the assessment order which starts at page 9A, I suppose. Yes. Kindly take the second paragraph at page 10. From the above, an apparent suspicion arises that the assessee company acquired this loss from share trading to set off its interest income to escape tax. It is found that from the details submitted during the course of hearing, that entire trading of shares was in the script of private limited companies which is traded off market. My understanding, subject to your lordship's kind consideration, obviously, but these details were furnished. And my lord, it is on the basis of the suspicion that this order has been passed.
All right. Based on suspicion, information from the investigation,
and my lord,
post a show cause notice.
And
your case is selected for scrutiny, found the submissions filed during course of hearing.
Yes, during the course of hearing. That is,
involved in
the assessee filed
tax audit report filed during the course of hearing. Following particulars are found. It transfer share trading loss is set off from a large interest income.
The allegation is that the director made a statement on oath. But I will come to the retraction later on.
There was no search, but there was a survey on the assessee.
Yes, certainly, my lord, certainly. Director made a statement on oath. Director made a statement on oath that, my lord, the director is a accommodation entry operator. That's the allegation, my lord. That's the statement on oath. But on the basis of commission that he is to give these accommodation entries. My lord, this is assessee's own case, where assessee sells the shares. But there is no question of accommodating his own finances in this manner. It may be in respect to other parties. Let me take the worst case forward. It is his own case. It is not the case of any. It is with respect to a statement recorded with regarding KLJ Group of Industries, not his own case. This is exactly what is there. Kindly take, my lord. The statement was recorded during the course of, my lord, survey operation carried out in the premise of KLJ Group of Industries.
Survey,
but not his own case. So whatever accommodation, even if it is believed to be true, believed to be correct, whatever accommodation entry the assessing officer is referring to, it is with respect to that group. And this is sale of shares, his own shares.
Retraction was after the assessment was completed.
I understand, my lord. That is why I am taking the worst case for the assessment.
Tribunal committed a gross error.
Kindly demand it. Kindly demand it. Because it has to be examined, because the retraction.
So see, was what do you say? Purposely avoiding the proceedings. Evident.
At least, my lord, that can be examined by the assessing officer even.
All right, we'll consider. Please come. This appeal filed by the revenue under section 260 capital A of the Income Tax Act 1961. is within bracket the act is directed against the order passed with Income Tax Appellate Tribunal A Bench Kolkata in ITA number 61 within bracket tribunal in ITA number 614/K1/2023 for the assessment year 2014-15. The revenue has raised the following substantial questions of law for
So may I
consideration.
take the lordships kindly?
Page number 5, 1, para 3, 1, 2, page 6, 3, 4. We have heard sounds. The assessee filed its return of income, declaring total income of rupees nil, which was processed under section 143 within bracket 1, where a refund of rupees 22,83,940 was raised and issued. Full stop. The case was selected for scrutiny and statutory notices under section 143 within bracket 1 and 142 within bracket 1 were served on the assessee, calling for particulars. In compliance with the same, the authorized representative of the assessee appeared from time to time and explained the return and submitted the details called for. Upon perusal of the accounts and details, the assessing officer noted that the assessee is an NBFC involved in trading and investment in shares. Full stop. Interest on loan was received during the relevant period to the tune of rupees 2,45,85,201. And the net result of trading in shares is loss of rupees 1,97,94,148. After deducting other business expenditures, the net income was arrived at rupees 14,48,008, which was fully set off against brought forward loss, and the assessee company filed its return for the assessment year under consideration, showing nil income. On going through these details, the assessing officer found that the assessee company acquired its loss from share trading to set off its interest income to escape tax. And further also found that the entire trading in shares was in the script of private limited companies, which was traded off market, OFF market. In the meantime, information was received from the Director of Investigation from New Delhi that a search and seizure operation was carried out in the premises of KLJ Group, and consequential survey had taken place in the office of the assessee at Kolkata. The director of the assessee, Rajesh Kumar Surana, had given a statement on oath where he admitted that the assessee company is an entry operator and involved in giving bogus entry for purchase and sale of investment, share application, etc., against commission on total transaction amount. With these facts, a show cause notice was served on the assessee, setting out all the relevant particulars. And the assessee company was informed that the information shows the assessee company does not have any real business activity and the loss shown from trading in shares is bogus. Assessee was directed to show cause as to why the share trading loss of rupees 1,97,94,148 should not be disallowed as bogus loss. Sufficient time was granted to the assessee to respond to the show cause notice. The assessee, though received the show cause notice, did not submit any reply, and therefore the assessing officer proceeded and completed the assessment by passing an order dated 16/12/2016 under section 143 within bracket 3 of the Act. The assessee filed an appeal before the Commission of Income Tax Appeals, Lucknow 3. The appeal was dismissed by order dated 24/4/2023, and from paragraph 4.1 of the said order, it is evidently clear that the assessee did not participate in the proceedings, and despite several opportunities granted by the appellate authority, the assessee did not appear before the appellate authority. Thus, the conduct of the assessee before the assessing officer as well as before the appellate authority would clearly show that they were avoiding the proceedings despite knowing the consequences and consequences. There, in such factual background, the appellate authority considered all the grounds raised by the assessee and dismissed the appeal. The assessee filed an appeal before the tribunal challenging the order passed by the CITA, Lucknow 3. The tribunal has allowed the appeal by the impugned order, over which the revenue is agreed. At the very outset, we need to point out that the order passed by the tribunal is absolutely perverse and calls for interference. We support such conclusion with the following reasons. The tribunal tribunal has rendered a finding that the assessee has filed evidences before the assessing officer as called for during the course of assessment proceedings. This is an incorrect. This is an absolutely factually incorrect statement, since the response of the assessee was to the statutory notices issued under 143 within bracket 2 and 142(1). After the assessee responded and furnished details, a show cause notice was issued proposing to treat the share trading loss as a bogus loss. Admittedly, the assessee could not substantiate with documents that the share trading loss was a genuine loss. The assessee did not appear before the assessing officer. Therefore, this aspect of the matter has been lost sight of by the learned tribunal. Apart from that, the learned tribunal has stated that it is a statement given by the director on 22/3/2016 has been retracted by filing an affidavit. Admittedly, the alleged retraction is beyond the period of 2 years. That too, after the assessment was completed by order dated 16/12/2016. Therefore, the tribunal ought to have taken note of the legal position and rejected such retraction as an afterthought. Even assuming the learned tribunal wanted to examine the retraction, then the learned tribunal should have gone into the facts and found as to whether the retraction was a valid retraction. No such exercise was done by the learned tribunal, rendering the impugned order as totally erroneous. That apart, the learned tribunal has stated that the assessee has not been given an opportunity of cross-examination. There is nothing on record to indicate that the assessee made such a request for cross-examination. Therefore, we are at a loss to understand as to how the learned tribunal could have recorded such a finding, which is contrary to facts. Thus, the impugned order, being perverse and outcome of non-application of mind, without appreciating the factual background and the orders and the non-cooperative attitude of the assessee, requires to be set aside. Accordingly, the appeal filed by the revenue is allowed. The impugned order is set aside, and the order passed by the assessing officer dated 16/12/2016, as affirmed by the CITA dated 24/4/2023, are restored. Full stop. Consequently, the substantial questions of law are answered in favor of the revenue.
Deep law.
Next.
I think item number 4, my lord, Mr. Amit Sharma is appearing for the appellant.
No. 4.
Mr. Mujumdar and Mr. Sharma is in code number 8, ma'am.
All right, not today,
Not this week, sir.
not this week.
My lord, not this week.
Next,
Item number 5.
My lord, I'm appealing for
For
the appellant.
respondent lordship. Lordship, the assessee has availed the VSV scheme and Form 1 has been submitted. May I submit the Form 1? And Lordship, the appeal may be kept pending because Form 2, Form 3 has to be obtained. Your Lordship.
so we'll adjourn it.
Lordship, can we adjourn the appeal?
My lord, Form 2 has been filed, so my lord,
Form 1.
Form 1 has been filed, my lord. So Lordship will record that, and thereafter, my lord, Lordship will.
Lordship.
Yes, yes,
We have heard so and so.
yes, 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 yes.
It is submitted by the learned advocate for the respondent assessee that the assessee has availed the benefit of the direct tax Vivad Se Vishwas scheme 2024 and has filed Form 1. Where do you get the date?
So 22nd April 2025.
22nd April
2025.
2025. Since it will take some time for the department to process this application, come on, let this appeal go out of the list. Liberty to the learned advocates to mention after the other forms are issued in
Got it.
favor of the assessee.
Deep love.
Grateful.
Next,
Item number 6.
My lord, I'm appealing in this case, my lord. On the last occasion, delay was condoned, and Mr. Surana was directed to file the. So, my lord, he has filed, but I'm told he's not well, my lord. So, Mr. Junjunwala, I think, my lord, I have tried to contact him. He said, my lord, Mr. Surana is not well. So, Mr. Surana's matters have been taken up by Mr. Pratyush Junjunwala, Mr. Bhaskar Patel. Item number 6. Surana file kiya.
But I'll speak to him. I haven't received instructions. I'll speak to him. My lord, may kindly keep it next week. I am unaware, my lord.
The matter is otherwise not a good matter. It's covered by the judgment of steel leather, my lord. And my lord, this is my share application, share premium money was received, and thereafter, my lord, they have submitted all the relevant documents before the tribunal. Detailed document place, and tribunal has relied on judgment of steel leather, and the order was passed. If your lordship will kindly see, my lord, the tribunal's order, my lord, page number 62, my lord. So the paragraph number 5. The brief facts is that, my lord, I'm skipping the learned assessing officer observed that during the assessment, assessing officer has received the assessee has received the share capital, share premium from the various persons, including the individuals and the private limited company, totaling to rupees 1 crore such and such share application, share premium through those during the course of proceedings, and in consequence to the inquiry conducted, certain details were filed by the assessee, but the assessing officer was of the view that the compliance notice of under 131 of the Act was not been made, and the assessee company as well as the application and the companies did not appear with all the books of accounts, and that the assessee failed to explain the nature and source of the LS sum, and that as the concluded the proceedings under section 68 at rupees such and such, and estimated the income at rupees 1 crore 49 lakhs. I agree with before the assessee CIT appeal, and CIT he and furnishes the complete details of name, address, and the income return of financial years of the share applicants. The CIT appeal held that since the assessee failed to produce the proofs of the share application money before the assessing officer, thereafter, my lord, in response to the 131, therefore, my lord, he has confirmed, and my lord, before the tribunal,
but the tribunal says
yes,
even the CIT has confirmed the fact
yes,
that all details have been filed before the learned assessing officer
yes,
as well as before him.
yes, but yes,
If that is so, the burden shifts on the revenue.
yes,
Then
and
why they dismiss their appeal when CIT appeals?
my lord, CIT's observation, my lord, if your lordship will kindly see, my lord, page 24, my lord, and my lord, the findings are, my lord, page 24, my lord, entire thing has been discussed, and my lord,
But all these people who are share applicants, they are all relatives.
yes, because both are all are relative, my lord. Yes,
4 lakhs, 8 lakhs.
Yes.
Probably some money routed through the relatives.
My lord, the CIT is finding, my lord, page 59, 60, my lord, he has my lord, if you page 24, if your lordship sees the grounds, And thereafter, several judgments were considered, and thereafter, CIT has said that in the case of Pavan Kumar versus such and such, held that it will be clear that the share application monies received by the SSE companies from certain companies which are no more in typical companies and the benamis bona fides. Therefore, duly the SSE has shown reasonable bona fides. Now, it is clear that the companies investing in the share capital and the companies are and the company are dubious means, and the evidences brought on the record by the SSE does not establish the bona fide to these entities. It is held that once the owners is proving the genuineness of the payee on the SSE, and the SSE has failed to discharge the same.
All right, sir.
And
So Surana's name can be recorded. This appeal by the revenue filed under section 260 capital A of the Income Tax Act 1961 within bracket the Act is directed against the order dated May 14, 2024 passed by the Income Tax Appellate Tribunal C Bench Calcutta within bracket Tribunal in ITA number 1393/KOL/2023 for the assessment year 2012-13. The revenue has raised the following substantial questions of law for consideration. Page 4 of the state petition, para 7, question A, B. C. D not required. D, E not required. We have heard so also. Respondent, you put the name of Mr. S.M. Surana. The short issue which falls for consideration is whether the learned tribunal was justified in setting aside the assessment order as well as the order passed by the appellate authority, by which the addition made by the assessing officer under section 68 of the Act was set aside. The assessee, in order to demonstrate the 3 parameters which are required to be established by them, had produced all the relevant documents, which has been noted by the learned tribunal in paragraph 9 of the impugned order. All the individual share applicants have furnished income tax returns, financial statement, bank statement, confirmation of account, and also confirmed the source of funds applied for making investment in the SSE company. The tribunal found that the individual share applicants are mostly relatives and known to the director of the SSE. All those documents which are filed before the assessing officer was once again placed before the learned tribunal. And the learned tribunal has reappreciated the evidence brought on record and found that the assessee has explained that all the individual persons have PAN numbers and they had an immediate source of funds which was utilized for making investments. The source of funds with the individual share application is not only the loan received from other applicants, but also from sale of investments and properties supported by copy of the development agreement, etc. Therefore, the tribunal on facts was with regard to the other share applicants, which are private limited companies, the tribunal found that all of them have furnished audited financial statements and their income tax returns, PAN details, confirmation of source of investment, copy of master data, and in some cases, copies of the assessment orders passed under section 143 within bracket 3 of the Act. Furthermore, the tribunal noted that that in the audited balance sheet, it is shown that at the time of making investment in the SSE company, those share applicants, which are private limited companies, had sufficient net worth in the form of share capital and reserves and surplus to explain the amount invested. Furthermore, the tribunal has recorded that the CITA has confirmed this fact that all details have been filed before the assessing officer as well as before him. If such be the question, such be the factual situation, addition could not have been made under section 68 of the Act, and therefore the learned tribunal rightly deleted the addition by allowing the assessee's appeal. We find no question of law, much less substantial question of law arising for consideration is accordingly appeal for his dismissal.
Grateful, grateful.
Item number 7.
Made peace, Your Lordship. But this is reopening on the fact that there was an accommodation entry, my lord, accorded by the
Respondent served.
yes, respondent sir. On the last occasion, delay has also been condoned.
Who appeared last occasion?
Last occasion. No one, no one.
No one has appeared, my lord.
Then you can inform somebody. Mr. Tulsian appeared before the tribunal.
We will.
Madam, Mr. S.K. Tulsian and Mita Rizvi.
I can inform his chamber, Your Lordship. Yes, sir.
No, though notice has been served, heard so also. Though notice has been served on the respondent assessee, none appears for the respondent. Let the learned advocate who appeared for the assessee before the learned tribunal be informed that this appeal will be taken up for admission next week.
Get for man.
Item number 8.
Assessee appeal. 602 days delay. Who appears?
Paraplan, I don't know that was the service been affected by the SSC.
Oh, service not yet affected.
But we are not appearing. Somebody should appear if service.
List the appeal. There's only prayer.
Ate nahi.
None appears for the appellant assessee. List after completion of service on the respondent department. Next.
Item number 9.
Item number 9, my lord. Perhaps my learned friend would opposing, but my lord, I am in a difficult position because my lord, above me, one senior standing counsel is there. Thereafter, my lord, learned ASG also there. My lord, learned senior standing counsel out of India due to his daughter admission. And my lord, recently, my lord, learned ASG has been appointed in this matter. My lord, he required some time. But an embarrassing situation, my lord, why I'm my lord, altogether, my lord, last occasion also I prayed time. But the department, my lord, says, my lord, something is required to, my lord, submit
All
before
right,
your lordship.
that is item numbers 9 to 14.
And if I may,
9 to, my lord, 15.
and if I may
9 to
indicate,
15.
but
Yes.
if I may indicate, my lord, that this matter had been heard by my lords at length earlier. The issue was that there was no incriminating material that was
Yes,
found
yes.
during search, and even before
All
the
right,
tribunal.
now that is difficulty is ASG has been engaged.
On Monday, if my lord, the matter may be taken up because my
Monday won't be possible.
but actually, the difficulty is, my lord, that there's a connected matter. The department is indicating it's a connected matter, wherein, my lord, a writ petition has been filed by us because the department has initiated penalty proceedings against the assessee for sections 271D, DA, and E, despite the fact that there is no recording or averment in the assessment order. So, my lord, they want to
That
keep
is, my lord, in
this
different
particular
parts.
matter alive.
You give a reply saying that don't take up the matter because
My lord, there is a, my lord, stay. My lord, there is a stay in, my lord, read court. My lord, there is a stay in the read
it
court.
is submitted by the learned senior standing counsel for the appellant, and that the learned additional solicitor general has been instructed to appear in this matter and seeks time to enable the learned additional solicitor general to appear. List the matter under the same caption on 5th August.
My lord,
Next.
By the date, my lord,
5th August.
5th
this
August.
matter, even I have a leader in the matter. By 7th August, if that may be convenient.
7th August, Thursday. Take a
Grateful.
Next.
Item number 16.
16, I am appearing for the respondent. Let the tax effect
My lord,
over
I am
here
appearing.
is only rupees 16 lakhs odd. They propose to
But
put me under the exception.
Exception.
Yes, my lord, but
These are
that,
penny stock matter. Penny stock matter.
but that in my humble submission does not apply in my case.
Yes, yes.
And if your lordship
It does, my lord. Penny stock matter, my lord. I'll make it very clear. See, edicta hai na. My lord, will
Just
kindly
one thing, you raise this preliminary objection by way of an affidavit so that they will respond. We'll decide that. How this exception will not apply.
Yes.
See, other day we decided one matter. They said it's penny stock. But the issue involved was nothing to do with the shares of the penny stock company, etc. It was totally a different issue.
True, my
So
lord.
therefore, we said exception will not apply. Monetary policy appeal disposed of.
Well, that I can certainly do. And if your lordship gives me 2 minutes, I can demonstrate from just one finding of the tribunal that this will not apply in my case.
My lord, that apart, my lord will see the scripts. The tribunal goes on the basis of a coordinate bench order. That coordinate bench order also, the scripts that have been spoken about in that are exactly the one that my lord has passed a judgment on in PL Goenka. Same, absolutely same. And thereafter,
All right, we'll take it up tomorrow. Not today. Item 17, Casta.
Item number 17.
17 is also my matter, my lord.
17, my lord, I appear for the response. But this is below threshold limit.
No, again, not.
Again, not covered.
No, no, no. This is not an income tax
Exception.
matter, man.
These
There
are
is no
custom.
question of these are customs matter. My lord, the duty component is, my lord, 81 lakhs.
There is no exception.
There is exception, my lord, that exception, my lord, this is not covered by that exception.
All right, we'll take it up tomorrow.
Very well.
Not today. So we'll let it- This is over. Aura building.
Your lordship, may I permit to mention a matter?
Appellate side.
Original side, your lordship.
You give the number.
Grateful, your lordship. Excuse
Which
me.
one? Appellate side. Second half.
Lordship, I had written 2 letters to you.
No, madam, sorry.
Uh,
You are not listening to anybody. Yes, sir.
Let's site, daily list, serial number 1, 2, 3.
Lord, in this matter, your lordships have been pleased to direct us to take instruction on certain points. Kindly see, my lord, the last order of 1st July,
1 second.
paragraph 13 and 14. First July 2025 order, paragraph 13 and 14, your lordships have been pleased to give us direction to take instruction. My lord, at page 7 of the order, the bottom paragraph, para 13. The next aspect which has been highlighted before us is that persons suffering from muscular dystrophy may require other devices such as these things, spine, and we are informed that these items are supplied free of cost by the National Institute for Locomotor Disabilities. Now, this aspect of the para 14, it is brought to the notice of this court that those items are required for persons who are in the early stage of muscular dystrophy and who are not wheelchair bound. Well, these are the instructions we have received in respect of this para 13 and 14. Dekhi, copy, go there, copy though. Go get a copy though. Well, this reference and response one side and response on the other side. Yes, persons suffering from muscular dystrophy may require assistive devices such as ankle foot orthosis, spinal braces to support mobility and
both they are agreeable to.
yes.
And now, what is the procedure for them to apply?
Procedure, actually, your lordships are not pleased to direct us to give us the instruction for procedure.
If the doctor certifies that the person is not wheelchair bound, and these devices will help them. With that certification, will they provide it?
Yes, in view of that, an application may be bad. We shall persuade the matter.
What do you say, madam?
Shibai, this is a very welcome news that they are ready to give it free.
Please thank addition.
We shall persuade the matter. Definitely no problem.
So we will issue a direction to the director saying that whenever a person suffering from muscular dystrophy applies for supply of any one of the assistive devices accompanied by
a certificate showing that they are suffering from that,
doctor,
from the medical.
And they will
kindly may not specify in the order that they shall make an application with the doctor's prescription and as instructed by them before your lordships, they will provide necessary facilities.
All right, one by one we will go. Reference may be made to the order dated 1/7/2025, in which we requested the assistance of the learned additional solicitor general. Paragraph 13 of and 14 of the order are quoted here and below. Paragraph. The director.
The Lordship would kindly come to the second page, Lordship. There is a particular scheme, it's written there. These assisted devices are provided here free of cost under the ADIP scheme, supporting individuals in maintaining mobility and independence by Pradhan Mantri Divyasha Kendra. So do we need to, go under the scheme?
You make an application to the National Institute, they will guide you. We are here, no? We will monitor the matter.
No, this is also situated at NILD. This is also situated at NILD, National Institute of Locomotive Diseases.
Yes. National Institute for Locomotive Disabilities. Within bracket, NILD, Calcutta, has given written instructions dated 21/7/2025 to the learned additional solicitor general, giving their response to The clarification sought for in paragraph 13 and 14 of the order dated 1/7/2025, which is quoted here and below, which has been quoted here and above. The response for better appreciation, the response received from the director, NILD is quoted here and below.
Physiotherapist তো বলেনি, সবার তো physiotherapist নেই, ডাক্তার কি
যে
নেই?
ফেসিলিটিটা চাইছেন তা স্পেসিফাইড ডক্টর প্রেসক্রিপশন করে
It can be in center, inlet, italics.
ভালো খবর স্যার।
আমাকে বলবেন আমি করি।
In terms of the above response, it is clear that the assistive devices will be provided free of cost. In terms of the scheme of assistance to disabled persons for purchase/fitting of aids/appliances within bracket ADIP scheme of the Government of India, which is situated at NILD. Therefore, we direct that all those persons who are suffering from muscular dystrophy to apply for the required assistive devices duly accompanied by a doctor's certificate certifying that the person requires such devices. Upon such application being made to the NILD, the same shall be processed and the assistive devices be provided free of cost under the scheme at the earliest, preferably within a period of 4 weeks from the date on which the application is made. We place on record our appreciation for the efforts taken by the learned Additional Solicitor General of India. Then next.
Then my lord, para 16, kindly come, para 16 of your office order.
How it can be uploaded in the portal.
This instruction we have also got this instruction.
Sir, our team is very hardworking. I have to appreciate that.
The first page is very important. Standard operating procedure to handle the cases where type of percent of disability or both of PWD has changed, or where PWD who has already been issued UDID card, disability certificate, migrates permanently in other state union territories. This is the first page instruction.
Flow chart has
and
been
this
given.
Goes on the next page.
So what you can do, madam, as a test case, you can ask somebody to upload the detail.
Yes.
And come for if there are any problems faced.
Any hurdle faced, well, we'll come back.
We'll come back so that in paragraph 16 of the order dated 1/7/2025, the following request was made to the learned Additional Solicitor General of India. Please quote para 16. The learned Additional Solicitor General has produced the copy of the standard operating procedure within bracket SOP to handle the cases where type or percentage of disability or both PWD, P capital, small w, capital D, has changed, semicolon, or where PWD who has already been issued UDID card / disability certificate migrates permanently to other state / union territory. The SOP also contains a process flow chart. We direct the learned advocates appearing for the petitioner to instruct their clients to upload the necessary details in the portal by following the SOP, copy of which has been handed over to the learned advocates for the petitioners, and inform this court as regards the outcome of such exercise. In the event there is any hurdles faced by those persons, the same shall be reported before this court in the form of a report reduced into writing. That's it.
My job is over. May I leave?
Thank you very much.
Now, Mr. Mukherjee is to satisfy your lordship on the other instruction. May I leave, my lord?
Yes. Then what are the directions for the state government?
There was a, before that, Lordship, your Lordship had directed the patient's mother to get one of the brochures for the wheelchair. So she has brought this.
Oh, which paragraph, Mr. Mukherjee?
Oh, paragraph.
So what medicine is concerned, man, kindly see the report 14 July to come under sanction for 2 months.
Supporting medicine.
Yes.
Calcium, vitamin D, pantoprazole, and all as others as necessary. Minimum. In which paragraph we have directed about that?
Regarding this
Medicines.
Lordship, that is and gives me a second.
Madam, you should have one junior to assist you.
Lordship, I should have, but
We'll send one junior to you.
Paragraph 4, Lordship.
How much you will give, you please tell.
Lordship, it's at paragraph 5.
Paragraph 4 and 5. 4 and 5.
Basically,
Paragraph 4 and
paragraph
5.
5.
Para. In paragraph. Take. I will take.
এটা দিতে পারবেন আপনারা ওষুধ?
In paragraph 5 of the order dated 1/7/2025, certain clarification was sought for from the state. The said paragraph is quoted here and below. Please quote paragraph. Mr. Tapan Kumar Mukherjee, learned senior advocate appearing for the state, has produced a copy of the order dated 14 July 2025, issued by the medical superintendent cum vice principal, IPGME and R -SSKM Hospital, Kolkata. From the said order, it is seen that in compliance of the order passed by this court, it has been ordered that other supporting medicines, within bracket, calcium, vitamin D3, pantoprazole 20 mg, pantoprazole 40 mg, and others as necessary, shall be dispensed along with the tablet Deflasport, DEFLAZACORT, for a minimum period of 2 months from the rare disease clinic, inverted comma, to the patient suffering from DMD to alleviate the symptoms and for general improvement of health of patients. The said order is placed on record and the same shall be complied with in terms of the directions issued therein by the medical superintendent cum vice principal. The person suffering from DMD shall make use of this order and obtain the requisite supply of the medicines for a minimum for a period of 2 months from the rare disease clinic. Then what else, Mr.?
Your Lordship kindly comes to paragraph 12.
12.
Page 7. Lordship, this is the quotation and Lordship, Mr. Vishnu Bhattacharya had, he is very
He's a very benevolent person.
Very benevolent, Lordship.
25 wheelchairs he is sponsored.
Lordship, I would also like to contribute 5. Lordship would record. It's not a very expensive. It's only
all right.
For 20.
Now, who will collect the money?
That is what they have a society.
They have given us
The
check details.
Check details
of one.
The society which is the petitioner number 1 here. So we will be giving the checks to that particular society for them to buy the necessary.
It is in the name of muscular dystrophy.
Patients'
No,
Patients'
no,
welfare.
no, no,
That is the petitioner in WPA P20 of 2020.
Lordship.
So all contributions, how much Mr. Mukherjee will contribute?
What I've already paid to one chair with 5,000, just finished about for personal order, so far as 5,000 per patients, but that is active consideration of the government. I mean, so for the medicines, we are ready.
The medicines we have recorded. Very good.
I'm told, the bank account is in the name of muscular dystrophy.
Patients Welfare Society.
Patient Welfare Society.
The
The
petitioner.
one line may be added, but that society may be exempted payment of income tax because
They have to apply for
That's
ATG.
a very good.
You apply for ATG first initially.
The income tax.
income tax and GST. While purchasing your
No. Society first. You contact some chartered accountant. He can file an application for ATG so that all donations get a tax exemption.
Yes.
Then you can obtain a 10A registration. But for that, I don't know whether your bylaws provide for that or a separate trust can be formed by the society itself. Think over.
For the society to themselves get a tax.
You please take the advice of Mr. J.P. Keita.
Okay.
He will be able to guide you.
Yes.
Or he will put you
Or
on
Mr.
to,
Abratosh Majumdar, one of them.
or they will put you to some chartered accountant
Yes.
who
I
do
will.
pro bono work for you. In paragraph 12 of the order dated 1/7/2025,
Read with 22 and 23. Read with paragraphs 22.
read with paragraph 22 and 23, a request was made to the parent of one of the patients suffering from muscular dystrophy to obtain a pro forma invoice from the company which supplies wheelchairs at very affordable rates. Accordingly, one of the parent has produced a quotation from Home Hospital Private Limited, which shows that the price of one wheelchair will be approximately rupees 8,809.52. On the last occasion, we had recorded
Government of India.
It's coming to 9250 for 20 wheelchairs, as per page 2. Kindly
One
see
second.
page 2. 185, 1,85,000 divided by 20 is 9.
No, in that order, we recorded all your submission. No? In which paragraph is that?
Our submissions, 20.
21.
22.
21, 22, and 23 were the persons.
Benevolent attitude of the learned advocates appearing for the petitioners in coming forward to sponsor wheelchairs. In order to purchase the wheelchairs, we direct all contributions be made to the Muscular Dystrophy Patient Welfare Society, the first petitioner in WPAP 20 of 2020. On receipt of the amount, the society shall arrange for purchase of the wheelchair and supply the same to the persons who are in need of the assistance of the wheelchair. The society shall make the payment directly to the supplier, namely Home Hospital Private Limited, whose bank details have also been furnished. It will be well open to the other members of the bar to also come forward to make their contribution if they so desire.
Paragraph 1 is very important. What the state government has thought on
that is after active consideration of the government, 5,000 per patient.
Please inform Mr. Purito Sinha and Shiv Shankar Banerjee. They are not here today. That day they were.
So I am concerned, I'll contribute it by today.
Thank you.
I have got the details of the bank.
Because Mr. Sinha said that the Incorporated Law Society also has agreed to sponsor 10 wheelchairs. You please inform me.
Very good.
That's a society's bank. No, if he is otherwise busy, leave him. Madam, Mitra madam, you please give your bank details, society bank details.
Lordship, I will give it to the incorporated law.
Learned
We have
advocate
already
appearing
given
for
a letter to Mr.
the
Sinha. I
petitioner
will add
WPA.
it.
What did you figure? I'm just putting it. Central Bank of India. I'll just write it somewhere.
The account number. No. Suppose some mistake occurs. No, all right. You have to give the IFSC number, bank.
Yes, I have the entire thing.
Then you write it. You write.
I'll write it.
It is better that you get the account number from the society and then do it.
They have given the account.
Correct, sir. We won't record that in
Very
the.
well.
Lordship, it would be actually
On the
quite
last occasion,
helpful if this.
there were other learned advocates who also volunteered to sponsor the wheelchairs. Let this order be brought to their notice by the learned advocates appearing for the petitioners.
No.
Then what else, madam?
Lordship, coming back to paragraph 1.
But that is under active consideration of the government.
How active, sir?
But now that whether it will be the health department or to the social welfare. Now the matter is because there are two departments, social welfare department and the health.
Oh, behind you, madam is standing.
Yes.
If she sanctions, everything will be all right. She is the ultimate deciding authority. You do something, madam. 5,000 rupees at stipend.
5,000.
Lordship, it will probably require the finance department's concurrence.
That is not your problem.
No.
That is madam's problem. She will handle it.
Sir, I will discuss in the health department that who will do, sir, from the behalf of COE.
I will also speak to the finance secretary.
Yes, sir.
Yes. In fact,
Will
he may come for a meeting today.
Ah.
You please put your best foot forward.
Yes, sir,
Definitely it will come.
definitely. Yes.
In paragraph 1 of the order dated 1/7/2025, the court made a suggestion to the state government to consider providing a stipend of rupees 5,000 per person suffering from rare disease.
Report in the form.
And the appropriate authority of the state government was granted liberty to respond to this suggestion by the court by filing a report in the form of an affidavit. Though a report in the form of an affidavit has not been submitted, Mr. Mukherjee, learned senior advocate appearing for the state, submitted that the matter is under the active consideration of the state government and the turn of events will be reported to this court on the next hearing date.
Lordship, 6 and 7 deals with the beds. Lordship had given a direction that there should be. That the state government was also supposed to consider.
6 and 7, what is your instruction? That is ICU.
Yes.
6, 7 and 8.
Kindly see.
একটা কাগজ দিলেন
আমাদের
যদি এক্সট্রা কপি থাকে দিন না
Report in the form of the not filed law. That sentence you remove. With regard to the facility of exclusive ICU unit for the persons suffering from rare disease, certain directions were issued in paragraph 6, 7 and 8 of the order dated 1/7/2025. The response given by the head of department, Department of Neonatology, Nodal Officer, COE, all capitals, of rare disease, IPGME and R, SSKM Hospital, Kolkata, dated 22/7/2025, is very encouraging.
You had told me about this gentleman, Mr. Lokit, but he didn't accept it because it was ahead with me incorporated. So no, it has to be.
And it appears that a detailed project report with site drawings and vetted estimates and financial implications will be submitted shortly. We request the concerned authorities to expedite the matter, and the progress be reported before this court on the next hearing date. In paragraph 9.
Lordship, Mr. Sinha is here. Can we use his good offices? He said he knows 2 Chamber of Commerce. So that was...
We'll come to it. We'll just complete this one. In paragraph 9, a suggestion was made for installing the necessary equipment for conducting sleep study test in the Kolkata Police Hospital along with BiPAP machine. The head of department, Department of Neonatology and nodal officer COE rare diseases has stated that sorry. No. You strike out that. And say, further it has been stated, increase in number of OPD days of rare disease clinic and upgradation of existing services for management of rare disease cases is under serious consideration. The provision of trained professionals like full-term medical genetist, DENETIST, and consultants from various disciplines, laboratory technicians, paramedical staff, dietitian, social workers may be needed in this regard. The requisite steps be taken so that the facility can be upgraded at the earliest. And what about that sleep study?
Sleep study is not separately mentioned, sir. Sleep study machine is already there in SSKM Hospital. So we are planning to upgrade our services at Kolkata Police Hospital and SSKM Hospital as well for the special test like sleep study, DEXA and pulmonary function test in a camp basis. So that's our plan, sir. So we can call the deserving cases for this special test in SSKM Hospital until we will be able to install one for the KPH.
It is further submitted by the nodal officer CEO of rare disease that so far as installing sleep study test equipment along with BiPAP machine, etc., the said facility is available in SSKM Hospital and necessary steps will be taken to install such equipments in the Kolkata Police Hospital, and until then the persons suffering from the rare diseases will be tested in the SSKM Hospital. It will take 2 months time, madam.
Sir, we will try to expedite it as early as possible.
It will be appreciated if the facility can be, if the such equipments can be provided in the Kolkata Police Hospital at the earliest, preferably within a period of 2 months.
Equipment with manpower. Equipment with manpower.
Technician is also needed, yes.
That is a problem. Contractual. You will give 6,000 rupees per month and ask him to work for 8 days in a week. 7 days a week.
That is
you will ask him to work for 8 days in a week of 7 days. And you give 6,000 or 8,000. I will give very much, instances where it's happening in the High Court administration. Ladyship knows more than me. 30 days, 31 days they are working, sir. They are paid for 24 days. 33 employees' name, I can right away give you.
And this problem all over India.
No. unique here. Unique here. Preferably within a period of 2 months. The head of department, department neonatology and nodal officer, CEO of rare disease, who is present in court, submitted that manpower is also required to be put in place. The state government shall take earnest steps to ensure that the requisite trained professionals / manpower is also simultaneously provided. Action be taken simultaneously for providing the requisite number of trained professionals / manpower so as to support the system. The state government can prioritize this issue and adopt measures so that the recruitment can be completed at the earliest and preferably within a period of 3 months from date.
One line may be added.
Until then, contractual can you not take?
One line, but the finance secretary may be direct to expedite the matter.
He can't. He is not a party here.
No, but when government is.
We have said state government. You are there. That's all.
Mr. Sinha.
Yes, Mr. Sinha is there.
I have not been not given the invoices yesterday evening. I'll make sure those are cleared and I have requested for a copy of the petition so that I can communicate with the
that they will furnish. Madam, what will be the cost of this sleep study equipment?
Sir, I don't know actually. I have to search for it, sir, because our hospital is already having 2 units. So
Roughly
I
about
get
2 lakhs, 1 lakh.
maybe, sir. I don't know the exact price.
What is it? It is small equipment like a.
Yes, sir, like EEG.
EEG.
So, but that a special software is needed for the pediatric population. And especially the pulmonologist, they are doing the sleep study, but need to have a proper expertise for reporting.
No, if Mr. Sinha can get some funds from the Chamber of Commerce, they give you the equipment. So what you can do is, whenever this rare disease clinic is open, one technician and one trained professional, whatever it is, they can come from SSKM to the police hospital, do the tests, etc., and then till you put the manpower in place. BiPAP machine won't be very expensive.
No, sir, BiPAP is not very expensive.
It's not even very cheap, Your Lordship. I think it would be in the region of 70,000 and odd.
It's around 1 lakh, sir.
So it's not always affordable for all these.
But the sleep study machine probably,
it will be
because it will also have consumables. Because it records like a graph, or it comes in the screen.
Electrodes.
Electrodes are there.
Software. It will be expensive, but
So, Mr. Sinha, we won't say, we will just give the copy of these orders. Madam will give you.
Yes.
And they have obtained the quotation for the wheelchairs. And
that has been given to me. That I shall not take care.
They will give the bank account number.
Yes.
And you can transfer it.
Yes.
They will purchase.
Yes.
Whoever wants to sponsor can be.
Yes. And as far as the other machine is concerned, if I could be given a copy of the invoice, I'll try either through the Chamber of Commerce, and there are other philanthropic organizations which may be willing to help. So if I can get that, I'll also try for that.
We place on record our appreciation to Mr. Pratyush Sinha, whom we had requested to represent 2 Chamber of Commerce situated in Kolkata. Since as of now, the sleep study equipment along with BiPAP machine is not available in the Kolkata Police Hospital. If the government can inform as to what would be the price of such equipments, Mr. Sinha would submit that. He will try to speak to the concerned persons in the Chamber of Commerce and other philanthropic organizations, requesting them to sponsor the said equipment. Mr. Mukherjee, if suppose they sponsor the equipment, you have to take care of the AMC.
That they will have to.
Here, a lot of senior advocates are ready to sponsor air conditioning for the bar rooms. But PWD is not willing to take up AMC. You please ask ladyship. So I said no. No, nobody need to. Mr. Abrutosh Madhundar said he will get 2-3 air conditioner for room number 13 or 12, somewhere where he is sitting. But PWD said no, sir. If we will not take care of maintenance, nothing we will do.
Everybody is.
See, at least the capital investment is saved. AMC you are doing for all air conditioners. Most of the air conditioners in the High Court are about 15 years old. In the CJ house, it is 18 years old. In the chamber, it was 16 years old. The engineer came and inspected and he said there is a chance of fire hazard. Therefore, they replaced one.
I have taken the matter with the PWD secretary.
So what to do? That will be the problem. If they submit, get the equipment, or they can raise the invoice. See, you can't accept money from them.
Yes.
So they can sponsor,
yes,
purchase the equipment, interest it. But you should bring it into your inventory and ensure maintenance of the consumables. If you fail to do that, then it is like E-committee sanctioned generator. You have not sanctioned diesel. You have not sanctioned generator operator. For 6 years in Barasat, the generator is lying idle.
Entire district, entire state.
Entire state, all generators are lying idle. Why? Fuel no sanction, operator no sanction. The equipment purchased out of E-committee funds.
Right.
Because of the e-governance implementation of the, what is it, the second plan or third plan, something. So what to do? We are being frank with you.
And there must be some meeting so that problem can be solved.
You call for some people, discuss with them, because they are all medical professionals. They are not supposed to be here.
Yeah.
They are not supposed to take care of administration. They are supposed to take care of something else for which they are qualified. So if suppose 2 equipments, Mr. Sinha is able to get a sponsorship, then how they will maintain?
There must be some persons to permanent.
You have to receive it,
yes,
as a gift or something, and bring it into your inventory and then maintain the equipment. Otherwise, it will be lying idle.
I'm sure the donors will be willing to execute a document of gift if required, just to
that
transfer it in their records.
They won't ask you to return the equipment back.
Yes.
One hurdle which this court perceives is that if equipments are sponsored by benevolent persons, the state government should be proactive to accept those equipments in its inventory and take care of its maintenance. In this regard, a specific written instruction be furnished by the concerned authority of the state government, or else sponsorship of such equipment will become a fait accompli. List on so-and-so date. When it will be wanted. Sir, you try to upload that and find out.
That I will. May I make a few submissions? The report will be submitted by the Secretary Department of Health.
We don't know.
No, otherwise only difficulty.
We are not here. You know your rules of business. Who has to take care of the equipment, etc. The administration will take care. We have said appropriate authority. Yes, sir. Thank you very much.
Well, with regard to the UDID cards, I have taken instruction what is the present situation. So, my lord, they are saying that there is no SOP. So, therefore, different hospitals are doing it differently.
But today, ASG has handed over this SOP.
No. That is with regard to the uploading. Here,
uploading the what is it? In case
uploading the card for renewal.
No, percentage of disability.
Percentage of disability change. Here, the difficulty is that I have been informed that RG Medical is asking for counselor certificate.
Which counselor?
residential, corporation councillor, municipal councillors. Whereas other NRS and all, National Medical College, they are not asking for that. They are going by Aadhaar.
First you will ask the Pradhan to give certificate, then the local MLA, then MP.
Now, my lord, to continue, my lord,
I think Aadhaar certificate is there. That would be sufficient that he is a resident of India. That would be there.
Your Lordship's order will make it clear that these hospitals should not insist on the councillor's certificate. There should be one standard operating procedure, which is to be followed by all hospitals.
All hospitals.
Yes, my lord, that would be otherwise, my lord, because what is happening, my lord, these persons with disabilities, they are talking to each other. They are taking instruction and advice from each other, going to the hospital, and the hospital is turning them away.
You are appearing for petitioner in WPAP 9 of 20.
9, my lord.
Mr. Kaushik Gupta, learned advocate, appearing for the petitioner in WPAP 9 of 2023, has highlighted the difficulty faced for obtaining the UDID card. It is submitted that different hospitals follow different operating procedure and there are no standard norms. It is submitted that one of the government hospital insists upon the certificate, residence certificate to be issued by the councillor of the local
municipality.
We fail to understand as to what will be the necessity of a councillor of a municipality or a pradhan of a panchayat to give a certificate when there are better documents by which the identity of the person, the permanent residential address, the age, etc. can be ascertained. Therefore, all hospitals in the state of West Bengal should adopt a uniform procedure for with regard to production of the what do you call it?
With regard to the UDID card, the disability
production of the details for obtaining the UDID card, and definitely a certificate from the councillor of a municipality or a pradhan of the panchayat should not be insisted upon, but other records can always be accepted, such as Aadhaar card, ration card, bank passbook,
voter ID,
driving,
passport.
तो पैन कार्ड लगेगा
पैन कार्ड तो दीदी एड्रेस থাকে না
No, if the parent has a driving license, parent
driving license of the parent,
driving license of the parent of the patient suffering from rare disease, etc. In this regard, the appropriate authority of the state government shall pass an order and such order be placed before this court on the next hearing date. You pass an order to that effect. Standard, all of you should adopt a uniform procedure. Sir, to obtain a certificate from the councillor,
I'm sorry for that.
it is next to impossible. We don't want to say anything more.
It is better not to go to the councillor or not to the pradhan.
Now, my lord, with regard to now what has happened is there is a circular of the department of 5th September 2019, whereby ward-wise hospitals have been allocated. Now, for example, Bangur Hospital has 94 to 106 and 111 to 114. Now, for people in Dom, initially they were going to Arjikar. Now they have been sent to Salt Lake Sheva Hospital. The data has not got transferred. So Salt Lake Sheva Hospital has no data of them available in their record.
One other issue which has been highlighted
completely
is regards the unavailability of data in the hospital when there is a change of hospital to which the patient is referred. By way of illustration, it is submitted that one patient was being treated in the RG Kor hospital who was a resident of Damdam. And recently he has been directed to take treatment in the Salt Lake Seva Hospital. But the data has not migrated from RG Kar Hospital to Salt Lake Seva Hospital. The appropriate authority of the state government / authorities of the RG Hospital administration shall ensure that the data of all such persons are migrated immediately as and when the patients are referred to some other hospital for treatment.
My lord. And my lord, I'm sorry, my lord, it's very upsetting, my lord, but two more points.
No problem.
In NRS, I'm told that in NRS, the PWDs are expected to visit the basement for medical board assessment.
Yes, that's
Is it-
because I have been to NRS. That's right. correct.
Visit the
Difficulty in accessibility. How to go to basement?
Because I had a lot of difficulty in taking my son because my sons were in wheelchair.
there is no ramp.
Yes.
There is no ramp.
No.
No ramp.
Today I have received a representation from a client from a party who's 90% disabled, and he says he is not able to access the High Court.
The car parking area. So we had a plan, but we couldn't implement because of that.
PWD couldn't implement, though we wanted it to be done in the B gate because of the car parking problem.
Yes.
So we have suggested that at least wooden ramp can be provided.
But my lord, within wooden ramp, there has to be supported rails also.
Yes.
And that has
Lordship, it should not be in the basement in the first place. Basement means automatically they will have to take the stairs. Therefore, if it would be very, very preferable to have everything for them in the ground floor.
It is
First floor.
Ground floor.
Ground floor.
The learned senior advocate further pointed out that one of the patients is under treatment at NRS hospital.
NRS.
And accessibility for the patient is almost next to impossible since there are no ramps provided. Providing ramps and facilities for the persons with disability is a statutory requirement, and failure to do so by the state would result in serious consequences. The Public Works Department shall take note of this and provide appropriate facilities so that the patients are able to access all the premises of all the hospitals. Then,
And also the major difficulty is happening with the non-training of staff. Now, what is happening, what has been informed to me, that for example, children with autism spectrum disorder being wrongly classified under mental illness. This misclassification has long-term implications, including their ineligibility for benefits under the National Trust Act, such as legal guardianship. There is no training of the staff who are uploading physically the data.
and in which hospital is this?
No specific name has been given here, but
If you can get some more details.
I will get the details. I'll come back with the details.
Because uploading is done by the data entry operators. 80% of the department, all data entry operators are contractual throughout the state. Probably they receive salary in 3 installments. Daily wages is not paid as daily wages. It is paid as monthly wages. As I said, 24 days for 31 days. That 24 days salary is paid in 2 installments. Fellow has to hang himself, sir.
I should not say anything, my lord. Whatever.
It's a pity. Wherever I go, become melancholic about it.
And all over West Bengal, very major problem.
6,000, 8,000. How do you think they'll survive, sir?
Lordship, coming back to an earlier point, I've just been pointed out by my clients here. Lordship, in the flow chart that they were given, Lordship, they are supposed to surrender their original UDID card, and thereafter they will get after the board
No,
process.
you make a test of that.
So I am just saying that a time-bound period. Suppose the board sits after 6 months, they are without a card for that entire
You
period.
come forward with something in writing on the next occasion. See, otherwise you dump so much, then Mr. Mukherjee will not appear next time. And his junior will come and say, Learned AG is been director appear, he is not available. We know their modus.
Yes.
But because madam is there, we hope something will take place. List the matter on so and so date.
Lordship kindly keeps it in the month of August.
After 15 September.
No, please,
No,
Lordship,
my lord.
whatever we
My
get,
lord, we are
get it
what
from you.
whatever the
Whatever
community has received,
has come from your Lordship.
had it not been for your lordships, it would not have been
Happened.
come this far. my lord.
Nothing. There was no progress in
We are
this matter.
extremely grateful, my lord.
Lordship, whatever we are expecting is from your Lordship.
Sir, because it's because of your generosity we are waiting for our
No,
decision.
no, madam, you are cooperating. You please thank madam. She has left her hospital and she has come here, spent so much of time. Because we were able to come only at 2:40 because of administration.
Lordship, yeah, this is a date in August.
12th August.
12th
August.
12th August. Grateful, man.
Grateful to your Lordship.
Under the same caption. Any urgent matter is there? Nothing. Very urgent. Huh? I want one meeting.
Not very urgent.
Thank you very much.
My lord, I have a very short point.
That
point,
you want to
my lord,
withdraw?
Only your lordship wants to.
You want to withdraw? It's the shortest point.
That Tapan korbe ki?
No, he is not ready.
Then has.
The morning itself he mentioned. This is that item 4.
4 is mine, lordship.
4 is yours.
Okay. The Waybill penalty matter, lordship.
Tomorrow we'll take it up. I got a meeting to.
Okay.